to see your names or even your faces. Feel free to turn on your cameras if you want. It's a pleasure to see you and to hear you probably in the future with questions during our webinar on contribution of Russia to the development of international humanitarian law. And the topic is twofold. It's fascinating and it's so large that I think we should say in the beginning that it would be really difficult to cover it all today. So we will stay on probably the main issues that related to it. We are happy to say that the ICRC supported the idea of RANEPA University to organize this webinar that is directed to students and professionals in IHL who are interested in this topic. It's not a secret that many documents, many ideas that we enjoy today in IHL were developed with a great contribution of Russian Empire, the Soviet Union, and nowadays Russia. And I'm really happy to say that we have today two panelists, two experts, and one of them is Olga Glickman, Associate Professor of MGIMO University of the Ministry of Foreign Affairs of Russia. And the second panelist is Michael RIEPL, ICRC Protection Delegate, our dear colleague and the author of the PhD research on Russian contribution to international humanitarian law. Guys, happy to welcome you, Michael, Olga.
Hello.
Thanks. Do you hear me well? Great, great. So let's start and let's have this rather friendly conversation than conference. Before we begin, I would like to encourage participants to write their questions in the chat box. I think this would be more convenient for everybody, and we will do our best to approach the questions during the webinar. And probably, if there will be plenty of questions, we will be able to present a book of Nils Melzer on IHL comprehensive introduction to the best question. So let's see how it will go. Today, it's a little bit experimental way we organize this webinar, this meeting today. We're using Microsoft Teams, which should work well for all of us. Let's hope it will do. Okay, so let's begin. And Michael, well, my first initial question, I think, is a little bit about the Russian contribution, but also a little bit about yourself. I mean, how it happened that the one who is not originating from Russia, probably, or just prove me if I'm wrong, is interested the way that he decided to contribute his time and to make his PhD thesis on this specific topic. So what was of the interest for you in it, and could you give a little introduction on the agenda?
Absolutely. Thanks a lot, Andrei, and I'm very happy to be here with you today and to discuss with you and with Olga this, to my mind, fascinating topic. And the question is quite justified. You're absolutely right. I am German. I am myself from Bavaria. But I chose this topic for my PhD because for a long time I was interested in Russia and I studied the Russian language and I studied IHL. And at some point it struck me that it's quite interesting how there are two different narratives of what Russia has contributed to IHL. So it is quite interesting that outside of Russia nowadays, I think these achievements that are undoubtedly big achievements, and we will talk about what they are today, they have been a bit forgotten, and that is very unfortunate. Whereas inside of Russia, of course, in the Russian dialogue, in the Russian academic dialogue, but also well, beyond the academic sphere, this heritage and this legacy is very much still alive. So I wanted to see for myself what really is the Russian legacy with regards to IHL. And yeah, thanks for opening the discussion, and maybe allow a quick remark on terminology before we go into what actually the Russians' contributions were. And I'll try to be brief and just give a brief overview before handing over the word again to you. So when we speak about Russia, of course, this is a very crude generalization, because in this presentation we will speak about basically three kinds of Russia. We will speak firstly about the Russian Tsarist Empire, then we will speak about the Soviet time, so the Russian Soviet Federalist Socialist Republic that then was incorporated into the Soviet Union and the Soviet Union as a whole. And finally, we speak, of course, about Russia as we know it today, the Russian Federation, born in 1991. So the term Russia that we're going to use today is basically like one matter in three different states, like if you want to compare it to water, ice, and steam. But despite these differences, and they are not identical, I think there is a certain continuity, and that's also what I discovered in my research. So that's why we're going to ask the overarching question today: what is Russia's role in the development of IHL, of international humanitarian law? For those who are not so much familiar with the terminology, the laws of war, or the laws of armed conflict, how others call it. I think Olga will give us a little brief about IHL in general, so I won't go into that. But I would like to just quickly highlight three periods that I think are crucial in Russian contributions to IHL. So the first period, I call it the white period, you will see why, is a period of kind of respectable but spontaneous manifestations of humanitarianism. It ranges from around 1850 to 1867. And there were some precursors of humanitarian organization. We might talk about some of them later, for example, the Orders of the Sisters of Mercy, Siostry Miloserdie. But there was also no legal framework. There were no rights, no conventions, no commitment that bound states. So that's why I would call it the white period, because it's like white, like a white piece of canvas. The second period, which is the period we might focus on today, I call the golden period. It ranges from around 1867 to 1918. And in this period, Russia really displayed huge commitment to developing IHL. So hence the golden period, because these contributions are truly unmatched, I would say, by any other state at that time, definitely, and arguably even afterwards. So we go through some of the milestones, but there were the St. Petersburg Declaration in 1868. There was the Brussels Declaration in 1874. There were the Hague Conventions in 1899 and 1907. Which were the first comprehensive code of warfare. And there were many smaller treaties banning certain weapons or means of warfare. So it was a really, really fruitful period for IHL. And finally, the third thing, after the First World War, we start to see what I would call the gray period. It is a time of, well, let's say, steady ups and downs. There were definitely great contributions, and we will talk today, for example, about the Soviet contributions to the 1949 Geneva Conventions. Another one, for example, being the Soviet contribution to international criminal law and the trials of Nuremberg. But there were also very, very low phases, and IHL was very much under threat, especially also in the Soviet system. So the most fascinating period, of course, out of these three is the golden one, and I think we might focus on this one today. And there are three things that are very, very, very fascinating about this period. So first of all, Russia was the most important state in advancing IHL, outshining even Switzerland and, well, we can discuss this question today, but I would say at that point, outshining also the ICRC. And I've already mentioned some of the milestones. Secondly, Russia really also practiced what it preached, you can say, because they made huge efforts to implement IHL on the battlefield. For example, in the Russo-Turkish War 1878 and 1879, or the Russo-Japanese War in 1904-1905. What does it mean? They issued, for example, military manuals, they criminalized war crimes, they had tracing agencies for POWs, they even imposed non-binding laws as binding on their army. And finally, and with that, I'll soon hand back to you, the most fascinating thing for me personally about this period is the reasons why Russia promoted IHL. And I might start with a little spoiler, because one might think that the reason for promoting IHL was simply humanitarianism. And of course, there was a humanitarian zeitgeist in the mid-19th century. There were pragmatic reasons behind promoting IHL, some of them economic, some of them military. And basically Russia at that time realized that promoting IHL in a multilateral way could also tackle internal problems and achieve its external goals. And this, to me, is really the crucial point. And I beg the listeners to bear this thought in mind. It'll become more and more clear in our discussion, because Russia really acknowledged that promoting international law is not contrary to state interests, to genuine state interests that every state has, but actually it may further them. And I think that's a very, very valuable lesson that we can also learn today. Please, Andrei.
Yeah, thanks, Michael. Yeah, thank you very much. Well, definitely depending on where you are and I mean, what you know about the subject, you could have different approach to the level and to the understanding of the input of this or that country, or in our case of Russia, into IHL development. But what is really interesting for me, and thank you for your response to what was of your interest, is that as you've mentioned, some states could, in some situations, consider that IHL, development of IHL or enforcement of IHL is somehow could be not in line with their policy or with their interests, which is definitely a mistake. But sometimes it happens, we see that. And it's very interesting that the example of Russia shows that it was not anyhow contrary, but it contributed a lot to the visibility, political image, great political image of this country. And this is a very interesting thing, which definitely could be considered very important these days as well, not only in 19th century or beginning of the 20th century. So, but IHL, to which extent IHL is important today? And I would like to switch to Olga and to introduce her to public. So Olga, please, what do you think about the IHL today? What is it today? And while talking about the history of IHL, while talking about the contribution of Russia or any other countries, what were the main stages of development of IHL, if I could say so? So could you please elaborate on this a little bit? Olga, unfortunately, we don't hear you. Are you still with us? We have lost Olga for a while. I think she will reload it, and then we'll continue the discussion. I hope everything goes fine with her. But okay, Michael, you have split it in your research. You have split the periods into 3 periods, which are all of them are important. We will come back to the IHL while Olga will join us. But the very beginning of what we call now IHL, because in many manuals we could find that technically IHL, or the rules on mercy, the rules on of behavior during the warfare, is not something new that was developed in 19th century. And I think while starting talking about the Russian approach, we shouldn't say that even before the very first documents and before the very first Geneva Convention, we saw the examples of institutionalizing this good behavior towards the wounded and sick during the armed conflicts. We will come back to this. I see Olga is with us now. Olga, do you hear us?
Yes, yes, hello.
Hi. Hi. So we were talking about the IHL and what it is today. So could you elaborate a little bit on this?
Yes, thank you very much. First of all, I'm very happy to participate in all events organized by Moscow delegation of ICRC. When I was a student, I started to learn IHL. It was very interesting, and I was very impressed by human ideas, like all my friends and colleagues now. That's why we are together, and that's why today it's very important to discuss these questions. As for IHL, what it is today, I think that IHL is a system of international law rules which regulate relations between a subject of international law and other belligerent in times of armed conflicts. In general, IHL works in different times in armed conflicts. But however, today they see that some rules are applicable in peacetime, and it's very important. For example, obligations to undertake measures to protect cultural property, or for example, to eradicate explosive remnants of war. I also think that due to the fact that the main international treaties were adopted during the Hague and Geneva Conference, IHL norms are divided into parts, but this division is rather conditional. The law of the Hague norms that limit means and methods of warfare, the law of Geneva norms that regulate protection of victims of war, those who do not participate in hostilities, and those who do not participate in hostilities anymore due to different reasons, because, for example, they were captured. Contemporary international treaties regulate international armed conflicts and in smaller scale armed conflicts of non-international armed character. However, today, the significant changes in type of conflicts in this century is very important. Today, modern conflicts are not wars against and between states. They are non-international conflicts with a very difficult character, and often modern war conflicts are conflicts with many different non-state actors being supported by different states. So we see a very important base of international treaties, IHL treaties and customs, but we also see a lot of gaps which should be regulated. And I think that today we should speak not only about historical position and role of Russia as for the development of international law. We should take into consideration this role, and we should think about what we should do today to regulate modern problems using this very unique role of Russia. Thank you.
Thanks, Olga. Thanks a lot for this introduction into IHL. Well, we are all here actually to discuss this very significant role, but let's talk about the specific issues. Let's give some examples of what was happening during the previous time. I have started already that even before the ICRC was established, even before the Henri Dunant's famous book on Solferino, and before the first Geneva Convention, there were traditions in Russia of organizing the society or organizing the movements to support wounded, to support those who participated in hostilities. So that was the predecessor of a national society of law. But then, with the development, we see, I would say, one of the most important document. I would rather say even that of that time, and probably of these days as well, being adopted. I'm talking about the St. Petersburg Declaration. So let's talk about this specific example, because I think the document itself, for everyone who reads it, is great. I mean, even today, if you would dare to compete with the formulations of the preamble, let's say, of the document, I think it would be really difficult to do that. So let's talk about the St. Petersburg Declaration of 1868. Michael, what do you think about it? And do you think that this is a very good example of a very relevant input of Russia, and in general, a very interesting and important document for the IHL?
Thanks, Andrei. Yeah, definitely. It is the opening salvo, and then it really opened and started Russia's engagement with IHL. Let me maybe quote the full name, because sometimes when you actually look at the declaration, first of all, especially those maybe not familiar with IHL so much, and I know we also have some students, for example, with us today.
Sure, please do.
You wonder why actually this document was so important, because the full name reads the Declaration renouncing the use in times of war of explosive projectiles under 400 grams weight. So it's quite a specific convention. Why did this become so important for the development of IHL? Well, first of all, and we can talk about the question later, why exactly this weapon was banned. But first of all, it succeeded in banning a specific weapon, actually banning this weapon before it was widely used in the battlefield, which is quite rare. There are only a few other examples after that where states managed to actually be wiser and ban the weapon before it was used in the battlefield. And the second, and that is probably the most famous reason, and that is the reason why we still think of St. Petersburg Declaration as such a milestone of IHL, is because it had a great preamble. So the preamble was really, really decisive for the development of IHL, because it laid down very, very basic points that we find today in IHL, in the principle of distinction, in the principle of military necessity, in the prohibition to cause superfluous suffering, and the very broad principle of humanity. So these four things, if you go through the preamble, you will find them in each paragraph in the way I've listed them now. And of course, that was like a roadmap for the development of IHL. And this is why the declaration up to this day is still seen as such a major milestone.
Yeah, thanks. Yeah, indeed. But actually, why it's 400 grams, Michael? Do you know the response?
Yeah, well, I mean, it's a very interesting story. So basically, you have to go a bit back to the context of what the situation was like in Europe. And there was Russia was embarking on some kind of reforms, of course, internally. Externally, they found themselves in a conflict with the British Empire, the so-called Great Game. So to cut a long story short, there was a possibility of a war lurking ahead. So the Tsar was very concerned that in this war, of course, there would be latest technology, military technology would be used also against Russian servicemen. And actually, he was specifically worried about one invention that was made by his own countrymen. And these were bullets that were exploding on impact. And originally, they were created to explode on ammunition wagons, for example. But then they were modified, and soon they could be produced so they explode even on softer surfaces, for example, a human body. And you can imagine if an exploding bullet hits your body, this will cause not only some injury, but significant injuries that go beyond what was necessary to disable the soldier. So because of that, Russia faced a dilemma. At the one hand, they were at the forefront of military development. At the other hand, they feared the impact of this weapon actually on their own soldiers. And the Tsar Alexander II was quite far-sighted, and then initiated, together with other Russian statesmen, this Russian initiative, the St. Petersburg Conference. And when the conference actually started, it was not so clear what weapon would be banned. For example, Prussia, if you go to travaux préparatoires of this conference, Prussia suggested to ban not just this weapon, but many other weapons. And then Britain was very much opposed, and they said, no, this would hamper our military development. And the Netherlands, for example, they would only sign a document if there was consensus. So at the end of the day, they chose this specific weapon because it was very harmful to soldiers. These bullets under 400 grams were most likely to be used against humans. Above 400 grams, they were most likely to be used against objects. And simply, that was the common denominator, so they could get consensus on it.
Yeah, thanks a lot. But quite often the question is, why exactly 400 grams? Why not 350 or 377? And I was researching on this actually for a while, and I have found that actually there was no reason for that. The main reason was that the bullets were much below 400 grams, and the missiles or shells were much more than 400 grams. So this was a kind of consensus to draw a line somewhere in the middle, not being, very clear on where to line it. We have just before we continue on this, and I think Olga will join us in this conversation. I just would like to mention that we have a lot of students joining us on video from RANEPA University, so we welcome them here. They are on one account, but that's great. We have a lot of our colleagues and a lot of very good specialists from Russia joining us as well. So please, dear colleagues, those who joined us in Microsoft Teams, if you will feel that you want to contribute or to state a question, but I would like to ask you to keep very short on this. Please raise your hands, and I will do my best to find the time to allow you to contribute and to participate online as well. And let's continue with the St. Petersburg Declaration a little bit, despite we have time running out. Olga, what do you think about the St. Petersburg Declaration? To which extent it's an important document, and to which extent it influenced the development of IHL?
Mm-hmm. I think that it's very, very important, and we call it some kind of constitution, IHL constitution, because this declaration has a very important idea to limit some kinds of weapons. And this idea, this principle of international humanitarian law started, it was developed after and is developing now. For me, this declaration is also very important for dividing combatants and civil populations. So it's not the idea of what kind of weapons. It is important that the idea of the limitation of some kinds of unhuman weapons. That's for me.
Yeah, thanks a lot. Mm-hmm. Yeah, please.
It was only it was very clear that it was only the first step.
Great, and that's, well, the great first step. Let's be honest. In addition to the context, which actually Michael has mentioned already, I just would like to add that if you would imagine what it was to fight in a war in 19th century, you should also understand that the level of medicine was much lower than it's today. There were no antibiotics, there were no proper treatment, and any wound actually in a body could be deadly dangerous, any. But when you have a wound like made by an explosive weapon, an explosive bullet, this would make the death inevitable of a person. Well, nearly that. So that's why it was, I think, behind this treaty, despite we all understand that in grid policy, states should have their political considerations, economical considerations, and others. For me personally, St. Petersburg Declaration is also a very good example of a humanity that was shown by a state, which is also, let's be honest, not that often happens when behind the document there are not only these clear political reasons, but also the reasons of humanity. And I think I could say that because if we would look for the future development of IHL, and we will look in the Hague peace conferences, to which I would like to switch now, we would say that we see this understanding of mercy, understanding of proper treatment for wounded and sick in the future development in the Hague conferences. What do you think about that, Michael?
Sorry, could you repeat the question?
Yeah, sure. No problem. I think that St. Petersburg Declaration and the humanity behind it is in line with the future development of IHL, to which I would like to switch now, the Hague conferences and the Hague conventions and declarations of 1899, 1907. So what do you think, whether this Hague conventions became a new step, an important step, and whether the idea of humanity and humanity approach, the principle of humanity in wide sense, was developed there as well?
Definitely. I mean, for IHL, the Hague Conventions were a huge step. Why? Because simply it was the first comprehensive code of warfare. So we have just mentioned that the St. Petersburg Declaration banned a very specific weapon. The Geneva Convention of 1864, for example, had some very specific rules on wounded soldiers and humanitarian action in this regard. But there was no comprehensive code of warfare that said, for example, this is a prisoner of war. This happens when a country is occupied. The citizens have the following rights and they do not have the following rights. There were no rules that went beyond specific rules on the conduct of hostilities. So these were all things that for the first time came up in a comprehensive treaty, and this treaty was the Hague Convention. And you've already mentioned that there are two. There was the first one in 1899 and the second one in 1907, which made a few modifications. So again, the context at the time was quite difficult in Europe. There was a lot of mistrust between European powers. And when the Hague Peace Conference in 1899 actually started, the priority was really on preventing a war and on disarmament. It then turned out to be, in the end, of course, a milestone for IHL, and also, by the way, a milestone for international arbitration, because the court in The Hague was founded in 1899 by the same peace conference. But really, the idea was to get states together to have an international peace conference to maintain peace in Europe. And of course, the very idea of humanity is inherent in this. And if you then read through the Hague Convention, besides the very specific rules, what is prisoner of war, what rights do people have during occupation, and so on, there is also the famous Martens Clause, about which we'll talk later, which is like a concretization of the principle of humanity. Or you could say, if there is no rule, in any case, you have to be humane towards people. So that's why it is definitely a step forward with regards to humanity.
Yeah, thanks, Michael. Olga, it's indeed quite well known that Russia contributed a lot to the conference. And as Michael has mentioned, how it happened that the conference, which was initially designed to be a conference on disarmament, became the peace conference. I mean, and how in general the development of the law happened and the development during the conference happened. Could you give a little bit on this?
Yes, thank you very much. I think that this was the role and the idea of Martens. He understood very well that it's important to discuss disarmament because the states were not ready to do and to really think about this. The Hague Conference really initially was designed as a conference on disarmament, but Martens understanding this unrealistic objective or this idea turned them into
Olga?
Lost Olga.
Such a pity. Okay, well, we hope Olga will come back on this. I apologize for this 21st century, but sometimes not really well operating internet connections. This happens sometimes. So yeah, coming back to what has been raised already. Indeed, the conference was designed one way, but then it turned a little bit different. And if we will see and I think, you know, quite often students, they mix, they say, okay, why the two conferences actually? Why it's 1899 and 1907? And definitely they say always that 1907 is much more important because many documents, many more documents were adopted there. Some of them were revised. So, and now that's why it's the most important one. But I think it's partially true because the first conference was really difficult to organize. And that was a lot of efforts from states to organize it. And the first experience of disarmament, the St. Petersburg Declaration, was before eyes, and many parties in Russia as well voted for this topic of the conference. But as Michael has said, I could only reiterate that some states consider that developing in this field could limit their potential, could limit their development. So somehow it turned other way. And the Hague Convention that Michael has mentioned, which in annexation established rules of warfare, I mean, was a really good development. Olga, you are now with us again, please. Do you hear us? Can you talk?
You're still muted, Olga, I think.
Olga, are you muted? Would you please? Yes, yeah. Now we hear you, please.
Sorry. Acts of Hague Conference became the first global codification and progressive development of two branches of international law, and that was very important. First of all, the law of peaceful settlement of international disputes, and also international humanitarian law. So these two main problems and two main ideas of Martens to mix all together these questions. During the first conference, the very first time on this level, in this scale, existing international customs on peaceful settlements of disputes and international humanitarian law were codified. As a result of the first Hague Conference, 3 conventions and 3 declarations were adopted. Then, during the second peaceful conference, Hague Conference, 42 states took part to improve these rules. And it was very unusual and very unique. They called it International Parliament because including this state, these states included European states, Asia, China and Japan, Central and South Africas. Such forum was unique for that time, and it was very important, and that the very first time in the history, new international treaties on rules applicable during naval warfare and rights and duties on neutral states were developed. As a result, 13 conventions and 1 declaration were adopted. And they include, first of all, like it was during the first conference, Convention for the Pacifical Settlement of International Dispute. It was improved. Convention relative to the opening on hostilities. Convention respecting the laws and customs of war on land. It includes annex to the convention regulations respecting the laws and customs of war on land. And today, there are 193 states parties to the United Nations. And only 40 states participate in the Hague Conventions. But their role and their significance is really very high. The majority of the conventions and declarations have been considered to express international customs, but themselves they are the sources of international law. However, not all the Hague Conventions adopted during the Second Peace Conference should be considered as international customs in force today. Among these acts, we see one convention that is not applicable and it is never entered into force, convention relating to the establishment of the International Prize Court. Some conventions are not applicable because of the historical reasons. Because, for example, today states prefer not to declare war like it was during this period. And a lot of experts consider that convention relative to the opening of hostilities is not applicable today, for example. But there are also some interesting facts. For example, in more than 10 years ago, Palestine and Ukraine 5 years ago ratified some conventions. So it means that they are very important today for regulating modern armed conflicts. The Hague Acts have been used in practice of international courts, starting with Nuremberg and Tokyo tribunals. Also, International Court of Justice quite often reference to the Hague Conventions and declarations in practice, including source of customary international rules. It was the Nicaragua case, Corfu Channel case, advisory opinion on legality of use of nuclear weapons, advisory opinion on the legality of building the wall on occupied Palestine territories, etc. And of course, we should speak about the role of professional martins, because I think that it's only because of this great professor, diplomat, the conference were successful.
Thanks.
May I add something, Andrei?
Yeah, sure.
Yeah.
Olga,
because I absolutely, sorry?
Because unfortunately the connection sometimes drops. So Olga, if you haven't finished, you could continue.
Later.
Okay, great. I mean, yes, Michael, before I give the floor to you, that's please intervene. Thanks a lot for mentioning this great amount of states from different countries, including Asia, Central and South America, I guess, participating in the second Hague conference. That was really a great achievement of that times. Yeah, thanks. Michael, please.
Yes, I fully agree with Olga about the huge dimension of these two conferences, especially at that time. And to understand the giant achievement of these conferences, maybe we should also say that, for example, the project of a comprehensive code of warfare, it has been tried before the Hague conferences, but it has failed. So the Brussels declaration that I've mentioned in the beginning of my introduction, actually, that took place more than 25 years before the Hague conference. And exactly there, Martens, he was quite young still there, and the Russians, as in, like, it was also a Russian initiative, they tried to get states to agree to a comprehensive code of warfare. And at that time, differences were so great that at the end of the Brussels conference only stood a non-binding Brussels declaration. So for Martens, he actually wrote in his book that just came out after this conference that it was one of the biggest disappointments, and he was absolutely shattered because he felt that this project that was very, very dear to him was a failure, and it had failed. And only 25 years later, Martens managed to overcome the same differences. And for example, the differences were related to the regime of occupation that was very uncomfortable for smaller states because they feared to basically get steamrolled by the bigger states like Germany in Europe, but also to the definition of POWs and combatants, because that dates back to an issue in the in the Franco-Prussian War. So there were the same issues still at stake, and Martens, and that was his great achievement at the Hague conference, Martens managed to overcome it, and one means of overcoming it, of finding compromise at this conference, was actually the famous Martens Clause. So that is not just that does not just enshrine humanity, but it was also, and there we see that Martens was not just a great lawyer, but also an amazing diplomat. It also managed to appease the states that had worries regarded to certain legal issues. So that was really, really important for IHL.
Yeah, great. Fully agree with you, and definitely, even now, we quite often read, as Olga has said, on the development of the conference, including, as I've mentioned already, the fourth convention with annex on the rules applicable during the warfare. And what is also important to say that I think for many states, these two conferences became a new dimension of thinking, let's put it this way. And when we reference to the 4 Geneva Conventions and additional protocols that we have now, we cannot, at least that's my impression, you cannot resist of referencing all the time to the Hague Conventions because of the relevance, because of the connection. And if you will look into the commentaries, including the updated commentaries prepared by the ICRC for Geneva Conventions, you will see quite often the reference to the Hague regulations, because that's a very important milestone, as you've mentioned, of the development. And a number of times we have mentioned Martens Clause. So I think that's a time to move on to the Martens Clause as well. So Olga, first question to you: to which extent you feel Martens Clause is really important? Because that's and why it's actually Martens Clause, why it's not someone else's clause?
Because during the first Hague conference, it was clear that states were not able to agree on all issues. Martens suggested to include in the preamble of the Convention on the Laws and Customs of War a clause. So it's a kind of stipulation. It's not a clause in legal meaning of international treaty law. This stipulation was fallen until a more complete code of laws of war is issued. The high contracting parties think it right to declare that in case not included in the regulations adopted by them, populations and belligerents remain under the protection and the empire of the principles of international law as the result from the usage established between civilized nations, from the laws of humanity and the requirements of the public conscience. What does it mean? So Martens thought about the role of international customs, also about the idea and the principle of humanity. We also see the term civilized nations. So this term is used in the statute of the UN, even now, in modern period. And Martens clause concerns the principles of limitation of means and methods of warfare and unique role of international customs in regulating warfare. This clause was later included in the Hague Convention adopted during the second conference, in Geneva Conventions, in 4 Geneva Conventions, in additional protocols, and also in the Convention of 1980 on conventional weapons. So we see that it was used and is using now like customary international law itself. Martens clause has a specific importance in nowadays in modern armed conflicts because the Hague Acts that regulate warfare between states became the ground for branch principles of contemporary international humanitarian law, humanity, discrimination between civilians and combatants, between civilian objects and military objects, prohibition of unnecessary suffering, prohibition of indiscriminate attacks, etc. By themselves, the Hague Conventions became an important step to adoption and development of principles of contemporary international law in general, not only international humanitarian law. For example, sovereign equity of states, cooperation, because the states really joined together to regulate these problems, peaceful settlements of international disputes. Diplomatical conference on the codification of norms of international law in order to resolve actual problems of international relations now are used in all different branches of international law, like airspace law, maritime law, diplomatic consular law, etc., human rights law. For me, the Hague Conventions designed many other directions of development of international law and put the ground for such development. For example, international human rights law, international responsibility, international criminal responsibility, international criminal law. We speak about it now. The Hague Conference and their outcomes proved the link between international relations and international law. And so they mentioned the role of international law in regulating actual problems of cooperation. They confirmed the necessity and possibility of negotiations between different states, even in a very complicated times. So today the situation is also very difficult, but the states should negotiate on these problems. This is still relevant as today we often witness significant disagreements between parties to armed conflicts. Also, I think that even those questions that were not resolved during the Hague Conference became the subject of future international law regulations. For example, conventions and international treaties about prohibition of certain types of weapons that were adopted later. It was possible. It was not possible to establish international arbitration for that period. They discussed this idea during a peace conference. But then the Permanent Court of International Justice was established. International Court of Justice as one of the main judicial, as a main judicial body, one of the main bodies of the UN organization also was established. The Hague Conference influenced not only on the legal rules, but also on the moral rules. And I agree with Andrew. I think that at least the participation of diplomats, lawyers, and professors is also very important, because the success of the conference also was possible because Professor Martens was not only practice and specialist in practice. First of all, he was a great scientific man, and still be. Thank you very much.
Thank you, Olga. Thanks a lot. So coming back to Martin's clause, Michael, to which extent it's actual today, actually?
Yes, I mean, Olga has already mentioned that the Martin's clause has become part of customary law. It's been reiterated in many, many treaties. I will not even start to enumerate them because I would just bore the audience. There are a lot of them, let's say the least. And of course, it is still relevant today, even though it's often accused of being too vague, too general. But on the one hand, we should not forget what it was. It was the product of diplomatic negotiations, and it was inserted to achieve a compromise between states. And on the other hand, it was a manifestation of humanity and a kind of fallback rule. If there is nothing else, we resort to the Martin's clause. So, of course, today there are much more rules than in 1899. So there are much less situations where you actually have to resort to the Martin's clause. But it is still, for some lacunas, for some gaps, it is still important and is still in force. And it's been reiterated many, many times. Excuse me. And actually, a bit tragically, I have to say, Russia itself devalued the Martin's clause a little bit in the pleadings to the nuclear weapons case in the 90s, because it argued, for example, that the Martin's clause was not contrary to the use of nuclear weapons. So, of course, we see the fact that they actually made a statement on this is already a sign that is still very, very relevant today.
Well, if to talk about the advisory opinion of the ICJ on the use and threat of use of nuclear weapon, which is a very famous one, and which we know was a kind of deadlock for the court to make a clear decision at this time. But at the same time, we should not forget about one of the questions that was stated before the court and which we decided to respond. And the response was anonymous, including the voice of Russia, of Soviet Union, of Russia that days, right? That was Russia already, of Russia, which says that in any case, application of a nuclear weapon in that case should be in line with IHL. So that was a clear statement that IHL is applicable to nuclear weapon. And that was also an important step forward because, as you've said, Martin's clause was drafted much earlier than the nuclear weapon established. And this is a very interesting and very important element to highlight, to underline that the legal regulation that is designed much earlier than the new means and methods of warfare happens or arrives, still relevant, still legally binding. That's an important thing when we make a line with cyber weapon or cyber operations these days. For example, this is also a very good example that Martin's clause as a part of IHL, as well as IHL in general, should be applicable to any new means and methods of warfare. Yeah, but we have actually running out of time, but we have a lot of questions. But we should not, I think, exclude the next period of contribution or the next period of discussions around the IHL, that period after the Second World War. I think we could switch there and to talk a little bit about the Geneva Conventions, 4 Geneva Conventions that we have now, and the further contribution of Soviet Union that days into the development of IHL. So, Michael, what on this? Have you developed this in your thesis?
Yes, because of course it is one of the, well, still probably the biggest contribution that the Soviet Union made to IHL, and it is quite an I call it an unlikely contribution, because the state of affairs right before the conference in '99 was very, very bad between the Soviet Union, the ICRC, and the Soviet Union actually was threatening to boycott the entire conference. There had been a Stockholm draft. They did not participate in any of the negotiations. And that would have really, I mean, in a two-block system, in a two-block world, if the Soviet Union and of course all of its allied states were to boycott the final conference in Geneva, that would have led to a very, very weak outcome, a very, very weak convention. Maybe just to say why the Soviet Union was so skeptical, there were many reasons, but one of the main ones was that they really blamed the ICRC for the many, many dead Soviet POWs during the Second World War. And we have to know that during the Second World War, around 3 million, it's an incredible number if you think about it, 3 million Soviet POWs perished in German camps. And they didn't perish, they were starved to death, they died of the bad conditions and other things. So that was one of the main reasons why the Soviet Union was really, really skeptical of the ICRC, because they said you should have prevented this dying. We all know that there were, of course, limitations, but that was the situation between these two entities. And then there was some attempts to reel them in, including actually excluding the ICRC from the conference or holding the conference in Prague or in Paris, but all of them were in vain. To cut a long story short, in the end, the Soviet Union actually did confirm the participation because they wanted to be rather in than out. And they actually had a very strong interests in influencing IHL and also using this stage, this conference, of course, to promote their view on the world, socialism, and so on. But nevertheless, this doesn't mean that the Soviet Union did not make a great contribution, quite the contrary, actually. And Claude Pilou, which was the then director of the ICRC, responsible for law and policy, he admitted that he hardly dared to think what would have become of the civilian convention, which is always quoted as the main achievement of 1994, the 4th Geneva Convention, without the presence of the Soviet delegation. So the real contribution of the Soviet Union were 2 points. First of all, they really pushed for this said civilian convention because the lesson of the Second World War was, of course, that there were ample protections for soldiers, wounded soldiers, combatants, but there were too few protection awarded to civilians. So the Soviets were among the main powers pushing for an entirely civilian convention. And ironically, actually, that meant that they sided with the ICRC, which they had very bad relations with previously. And the second major contribution was, and that might surprise some of you, Article 3. So Common Article 3 that extends IHL to non-international armed conflicts is one of the most important provisions of IHL, of course, still today. because it completely broadens the regime of IHL. And we know, and Olga has even mentioned it today, most of the conflicts are internal or non-international armed conflicts or internal conflicts, civil wars and so on. Actually, these international conflicts that were the blueprint, that were the base for most of the rules up until the Geneva Conventions of 1949, they're quite rare today. I mean, we really don't find them very often. So the fact that the Soviets managed, against the initial resistance of Western states such as the US, the UK, and France, to insert a clause that made IHL applicable in internal conflicts was really, really groundbreaking. And actually, yeah, I think even today, for the states who haven't signed Additional Protocol 2, Article 3 remains the sole treaty provision that applies. So, for example, for the US or other states. And finally, we see in the participation of the Soviet Union, however, a change in the relation to IHL, because they were really pushing for new norms. But on the other hand, there was a discrepancy because they did not practice as much what they preached as did Tsarist Russia. So they really, really were against any implementation mechanism for IHL. And actually the historian Boyd, who has written a very, very good article about the Soviet participation in 1949, said that they understood better than most imperial powers that they could accept virtually any text as long as it did not infringe upon their sovereign discretion to refuse outside supervision. So this is a real change compared to the Tsarist regime, not because they had many implementation mechanisms back then, but because intrinsically they really implemented IHL on their own initiative.
Yeah, thanks a lot, Michael. Thanks a lot for this insight. It's very true that unfortunately it's not well known the influence of Soviet Union to the development of Geneva Conventions sometimes, especially Article 3, which you have mentioned, and Convention 4. And it's a real pleasure to mention that thanks to work of our colleagues in Geneva, in the ICRC, we have a lot of documents on this conference and on other conferences on IHL as well, where ICRC participates, being digitalized and available now. It's an open access. So for those who research in this field, thanks to this work of the colleagues, it is possible to get the clear understanding without the quotation by others, by your own eyes, to see what was the development of the discussion during the conference and how it went, and it was really hot, I would say. And again, thanks to the Soviet Union and the other states, we have this very good development of Geneva Convention 4 and Article 3. We have actually a lot of other topics to discuss today, Michael, and I would like to apologize from Olga's name. She had to leave us. If I'm not sure whether she will be able to come back for the end of the webinar. So now there are two of us, Michael, and the audience, and I see a lot of outstanding names in the line of those who listen to us. But I would like a little bit to switch to questions, and probably through these questions to come to other elements of the discussion today. So we have some questions published on YouTube by those who watch us there, and we have some questions in Microsoft Teams. So I would start with some of them, and we will continue. So one question is in Russian in YouTube, so I will translate it.
Можно на русский тоже, если я понимаю.
Майкл, вы говорите по-русски?
Да, конечно, но без этого нельзя.
Yeah, it's great. I'm not sure that all who listens listening to us are speaking Russian and understanding Russian. So let's keep it in English these days. But that's great. That's great to know. On your opinion on the hack conferences, the question is from Valentina Petrova from Rostov University. So what do you think on this? Why negotiations between states that times were so short, and why these days states negotiate year by year on quite small treaties? So what has happened?
Yes, that is a very good question. Actually, now I'm stuck because I was trying to, of course, planning to pass all the difficult questions to Olga. Now Olga is not here. So no, it is really a striking point. If you look at the way how conferences were held back then and how quickly states found a consensus, and what is happening today, where negotiations drag on in working groups for years and years and years, it is quite striking. I mean, we have to see, of course, the Hague Conference was the culmination of a process, and actually there was talk of such an international peace conference for all throughout basically the whole 1890s. And I've quoted one of, I know actually I haven't quoted this in the beginning. I was supposed to say it in my introduction. There was a prime minister, English prime minister in the 1890s, who actually wrote to the Tsar, and that shows how really highly regarded Russia was in this respect at that time, saying that I'm quite clear that there is one person who's preeminently fitted to summon such a gathering, the Emperor of Russia, by his high, pure character and single-minded desire for peace, is the sovereign who appears to me to be marked as the originator of such a meeting. That's what Prime Minister Gladstone wrote. So the discussion was ongoing for many, many years. And secondly, there was, of course, already a blueprint for the Hague Convention, because I mentioned the Brussels Declaration in 1874. And if you look at the Hague Convention and the Brussels Declaration, they're very, very similar. I mean, there were additions, but they're very, very similar. But in general, I agree with you. It is absolutely stunning that negotiations seem to be a lot quicker. And that was maybe just linked to the zeitgeist at that time. States were much more ready to accept, for various reasons, treaties, hard law, than they are today.
Thanks, Michael. Let's move on. Well, we have a question, I guess, from Professor Bakhtiar Tuzmuhamedov. Can you read it by yourself, because it's a personal question to you? If you can see the chat. Yeah, then
it's opening. I'm sorry, the internet's a bit slow.
No problem. This is a question.
Where does
Okay, I could read it then. So in your thesis, you pose a question about Russia turning from pole to soul with regards to IHL, but soul was Paul, if only by other name, yet smelling as sweet, wasn't he?
Sorry, so this question I don't have, but basically on the question of from Paul to soul, and then the second part I didn't get.
But soul was Paul, if only by other name, yet
exactly.
Smelling as sweet, wasn't he?
Yeah. So yes, to explain, basically in my thesis, I have said I've reversed the change that Saul and Paul made. So we all know probably the story from the Bible. Saul went to Damascus. He had his Damascus experience, and he turned from an adversary into a defender of Christianity. And the controversial question I discussed in my thesis is whether Russia has the inverse process, whether they have become from an really, really strong defender of IHL today into the role of an adversary of IHL. I mean, of course, it's a simplification, and that's why it is always a good question to discuss, but it's never as simple as that. But of course, the point is that it is the same entity, even though we have talked about the concept of Russia in the beginning. And as Saul and Paul, they have just a very, very different relation to IHL and to the surroundings. But you have to say, of course, and that's why the comparison is simplistic, IHL today and IHL in the 1860s, 70s is completely different. They're completely different actors. Today, back then, IHL was largely state-driven process. Today, we have civil society actors that really take ownership of IHL. You only have to think about all the reports that Human Rights Watch, Amnesty International puts out. And even warfare, of course, is very different. So warfare in the 1850s, 60s has nothing to do with warfare in our times. So it's only natural, of course, that the relationship and the attitude of a state to IHL would change.
Michael, I have a very challenging task. I have many questions and we have just two and a half minutes. Thanks for this response. I would like to ask another one from our line and then to give the floor to Marina Gerasimenko, who has raised her hand already. But before that, Michael, the question comes from Kirill Yablochkin. I would make it a little bit broader than it was asked. Why we witness these days that states, one by one, quitting from international treaties. They quitting from the treaties on disarmament. They quit from the declarations to treaties. What it is needed to do to stop this, or at least to make this process of quitting from these instruments more complicated? Whether there is a solution, and you have 30 seconds to respond.
I'll be very short. So the very short answer is, I think we really have to revive the spirit in some way that limiting your sovereignty in treaties can be is not contrary to state interest, but it can be actually conducive, and it can actually further state interest. This is not just about IHL. This is about any treaty. And we see, for example, when the ECHR, European Convention on Human Rights, was adopted, that states had similar rationales. They think it was kind of a good control mechanism for their neighbors, but at the same time also they impose it on themselves. So if we can revive this spirit, that could bring back more of that what you've mentioned.
We are all dreaming on that. That would be really great, because when you read, the information about the high conferences, you really feel the spirit being in the air that day. Thanks a lot, Marina. You are online, please. Okay, well, just a sec. I'll check. Yeah. Does it work? Can you unmute yourself?
Maybe she can write it in the chat. I don't speak sign language. That would be difficult.
Yeah. Okay, we'll check. Marina, please unmute yourself, and you are online. Just unmute yourself. You can't. Okay. Okay, I did my best anyway on this. So if you can chat, then please do chat in the. I'm just looking whether there is no. Okay, so please type the question, just because I have allowed you to do that already. And before that, let me select another one to continue the short discussion. Yeah, definitely. I mean, Alexandra Pilaova has mentioned that there are other inputs to the development that Soviet Union and Russia made, and that is very true. And I apologize that we cannot cover everything. This includes additional protocols to Geneva Conventions, additional Protocol 1 and additional Protocol 2 for definitely. This includes participation in Nuremberg trial, which has been mentioned already, and actually which was a very significant step to the development of international criminal law. A lot of other examples. So this question is the one that rather I take on myself, and I apologize for not being able to approach all of this. Okay, so Marina, have you published the question? Okay. Michael, do you consider, do you see the question, Michael?
Do you consider revocation of the signature to the Rome Statute made by Russia 5 years ago as a step back in the contributing to IHL? So yes, I mean, again, I'll be trying to be very short. For the listeners to know, Russia has withdrawn from the International Criminal Court 5 years ago. And of course, the International Criminal Court is one of the implementing mechanisms for IHL, even though quite a novel one. In this sense, yes, it is one. And we see this not only with the ICC, we also know that Russia has withdrawn recently from the fact-finding commission. Actually, we also know that Russia has not alone. Russia is not standing alone there. It's joined by other states. Is very much opposed to any strong implementation mechanism, external implementation mechanism. So I think this is really what is the difference between the Russia in the golden time. I'm not saying that in the golden time there were external implementation mechanisms. They were not. But in the golden time, there was this intrinsic effort that we have and to be seen in Russia to implement IHL. And just to cite one example, it's very funny. If you read a military manual, and I forgot the year, but it threatens soldiers that they will face eternal torments on earth and in hell if they don't adhere to IHL. So that's a loose translation. So they were quite drastic about IHL. Yeah, it's probably not the wording we would use today. So yes, it is a step away from implementation, of course.
Yeah, but we see a lot of examples these days, unfortunately, by the great powers doing such steps, and that's the most the thing that is really one should be sorry about. And again, just to reiterate, Michael, that you have said that the solution could be definitely to reiterate, to get back the spirit of understanding that IHL is a development, is not a limitation. And I think this would be great. And this is, I think, a good phrase for the end of our webinar. I thank you very much, Michael, you and Olga, for participating. Thanks very much for your expertise. And well, thank you very much, our dear guests. I would like also to thank those who found the time from our colleagues and from professorial academia in Russia and in Geneva, our colleagues, dear colleagues, to join and to participate. So thank you very much for this. We would like to welcome you in our further seminars and webinars. Just to mention that we have a number of initiatives that are still actual today. We have the essay competition where you could participate and other initiatives. We are supposed to have QR codes for you on the page to follow the initiatives of the Moscow delegation of the ICRC to join Martin's Readings Conference that will happen next week. It's quite soon, so please go to the website and register and to participate in our essay competition, Robots and IHL. And I promised to give the book to the best question. Actually, Michael, I don't see you now, but are you here?
I'm still here, yes.
You're still here. So Michael, well, Olga has left, unfortunately, and I would like you to decide which question you consider being the best one or being the most interesting one. I have to give the book.
Off the top of my head, I really like the first question, which is very practical, but saying, why on earth are negotiations so long today and they were much shorter? Even though Jean-Marie posted in the comments, actually, a very good point, that there were less states simply because of decolonization and stuff. We have that would be my favorite.
Okay, I would vote in favor as well. So we will be happy to present the book to Valentina Petrova from Rostov University for this question, if I'm not mistaken. So thank you very much. Thank you very much, Michael. And thank you very much, dear guests, for your participation. Hope to see you soon. And well, follow the website, follow the conferences and initiatives that I've mentioned already. And see you next time. Thanks very much. Thank you.
Thank you very much, Andrei. And thank you, Olga, if you can hear me. Goodbye. Thanks for joining, everyone.
Thanks. All the best.